Yes, we start solving the questions of Indian Evidence Act. First of all, read the quotation. अपनी समस्याओं से भागना एक ऐसी दौड़ है जिसमें आप कभी नहीं जीत सकते. It means if any problem is relating to you, should not be avoided by you. Face them. Okay? Yes, we start. Point out the incorrect statement. In this question, there are 4 statements are given, and we have to find out the incorrect statement. Which statement is false, incorrect? First of all, if a contract is contained in several letters, okay, all the letters in which it is contained must be proved. All the letters in which it is contained must be proved. Yes, it is correct. If a contract is contained in a bill of exchange, but that contract, if is contained in a will of exchange, the will of exchange must be proved. No. The bill of exchange must be proved. It is not required. So, the statement B is incorrect, false. Because see, if a will exchange is drawn in a set of 3, any one need be proved. It means any one of them is required to be proved. If A gives B received for money paid by B, oral evidence is offered of the payment. The evidence is offered of the payment. Yes, the evidence is not admissible. Okay. So, sentence B is incorrect. Sentence B is incorrect. Contract contained in a bill of exchange, it is not required to be proved. Okay. Here must be proved. No, it is not required. So, it is incorrect. Next, a policy of insurance is effected on goods. Okay. In ships from Calcutta to London, the goods are shipped in a particular ship, okay, which is lost. Then ship is lost, which is insurance. Insurance company want to prove that particular ship was orally accepted from the policy. The insurance company has to prove it. If court want, may presume the fact cannot be proved, plaintiff must disprove it. It means the policy here, a policy of insurance is effected on goods in ship from Calcutta to London. It means the ship is going from Calcutta to London and goods are boarded. goods laden with goods and a particular ship which is lost. Insurance company want to prove that particular ship was orally accepted from the policy. Section 92 says that if the terms and conditions under section 91 is proved, then no further evidence is required to prove it. So it is not required to prove it because the terms and conditions are proved under section 91. So the fact cannot be proved. This is the correct answer of the question. Why? Because the fact contained in the policy insurance is not required to be proved, because if any contract, grant or disposal of property relating any document, disposal of property, it must be proved only by document. And according to section 92, if it is executed and proved under section 92, no words, terms are attached are required to be proved. So under section 92, the fact cannot be proved. This is the correct answer of the question. Section 92 of Indian Evidence Act applies to Section 92 of Evidence Act applies to where? Bilateral documents, unilateral documents, both A and B, either A or B. Actually, it is applicable both. It means it is applicable not only bilateral documents, but it is also applicable unilateral documents also. So option C is the correct answer of the question. It is the correct answer of the question. Why? No. It is not applicable in unilateral. It is applicable only on either party. Either party means A and B. So our correct answer of question third is A. A is the correct answer. Okay. Bilateral documents. Section 92 of Evidence Act applies to bilateral documents. Bilateral documents, it means on either parties. Those documents are produced by either parties of the contract, of the deed. If any contract is made between the parties and documents are produced on either sides, it means A and B. Both documents are required. So Section 92 of Evidence Act applies to bilateral documents. It is correct answer of the question. Okay. A is the correct answer. A agrees absolutely in writing to pay B ₹1,000 on the 1st March 2010. Okay. The fact that at the same time an oral agreement was made that the money should not be paid till the 31st March cannot be proved. Cannot be proved. Yes. Yes. A sells B a horse and verbally warrants him. Sound. A gives B a paper in these words: bought of a horse for rupees 500. B may prove the verbal warranty. Yes, both is correct. A and B, the both sentences in first and second, the both sentence is correct. So correct answer of the question number 4 shall be C. C is the correct answer. Okay. A sells to horse to B. A sells to horse to B and verbally warrants him. Sound. A gives B a paper in these words: bought of a horse for rupees 1000. B may prove the verbal warranty. This evidence is admissible. Yes. This evidence shall be admissible. So the correct answer of the question A, admissible. This is the correct answer. Okay. Next. A agrees in writing to sell a horse to B. A agrees in writing to sell a horse to B for rupees 1000 or rupees 1500 to show which price was to be given under Indian Evidence Act, because the error is on the face of the document. When the error is on the face of the document like it, then it shall not be required to prove orally. It should not be required to be proved by evidence. So evidence cannot be given. Evidence shall not be required because errors are on the face of the document. So evidence cannot be produced. So evidence cannot be produced under section 93 because the errors are on the face of the document. Okay. So the correct answer of the question B. When the language used in a document is on its face ambiguous or defective of facts which would show its meaning or supply its defect. When the language used in a document on its face ambiguous, it means on the face of the document ambiguity is clear, ambiguity is shown, then evidence is not required to prove. So here also evidence may be given, oral evidence may be given, documentary evidence may be given, evidence may not be given. Yes, because error is on the face of the document, no evidence is required. So the correct answer of the question 7 is D. D is the correct answer. D is the correct answer. In which of the following oral evidence may be given to explain? Oral evidence is given. In which of the following oral evidence may be given to explain? Where the oral evidence is required? The seller sold his house to the buyer with the sale deed, stating that his house is located in Havra, okay, while he has no house in Havra. His house is in Kolkata, yes, upon which he has the possession on the date of execution of the sale deed. It means evidence is required or not. Here the question is asked, in which of the following oral evidence may be given? In the option A, it is clear that oral evidence may be given. If here the ambiguity is not on the face of the document, it is not a direct ambiguity, it is indirect ambiguity. When the ambiguity is indirect, oral evidence may be given. The seller sold his house to the buyer with the sale deed, stating that his house is located in Havra, while he has no house in Havra. His house is in Kolkata, upon which he has possession on the date of execution of sale deed. This is the correct answer. The seller in writing sold his horse to buyer with a statement that the horse is sold rupees 1,000 or 2,000. It is ambiguity on the face, so no evidence is required. Some blanks are left in a writing. Seller wants to clear empty space. No. The seller sold his 100 bighas of land at Rampur by writing to the buyer, and he has 100 bighas land in Rampur. The seller wants to give evidence that he sold land situated at different place. No evidence is required, because the fact is true. When the fact is true, no evidence is required. So the correct answer of the question is A. A is the correct answer. A sells to B deed my estate at Raipur containing 200 bighas. A has an estate at Raipur containing 200 bighas. It means A sells to B by deed my estate at Raipur containing 200 bighas. A has an estate at Raipur containing 200 bighas. It means it is true. Whether evidence may be given of the fact that estate meant to be sold was on a different place and different size. No, it is not required. Different place and different size it shall not be proved. So the correct answer of the question, no. A sculptor agrees to sell to B all my mods. A has models and tools also. Whether evidence can be adduced to show his intention? Yes. Yes. Such evidence may be given. Such evidence may be given to clear his intention. It means he wants only sculptor or tools also. Which of his property, it means models, mods or tools, he want to sell. For it, the sculptor may produce evidence. So the correct answer of the question A. Yes. Thanking you for watching the video. That's all. Okay, thank you. That's all.